Hello, my name is Celina Marquez, and I'm a policy advisor at the U.S. Conference of Catholic Bishops' Migration and Refugee Services. Family unity and reunification has long been a foundational principle of our nation's immigration policies, and our laws have long incorporated familial relationships as a basis for admission into the country. Family-based migration allows both U.S. citizens over the age of 21, as well as legal permanent residents, to petition for certain members of their family to immigrate and join them in the U.S. Through this process, family members are able to apply for a green card and would ultimately have the option to become U.S. citizens themselves. There are two categories of family members that are eligible for this form of family-based migration. The first category includes the immediate relatives of U.S. citizens who are over the age of 21, such as their spouse, a minor child, or their parent. The second category is referred to as the family preference category and is broken into subcategories. F1 includes the unmarried sons and daughters that are 21 years or older of U.S. citizens. F2A includes the spouses and unmarried children under the age of 21 of legal permanent residents. F2B includes unmarried sons and daughters of legal permanent residents who are over 21 years old. F3 includes the married sons and daughters of U.S. citizens. And finally, F4 includes the brothers and sisters of U.S. citizens. In order to begin the process of family-based migration, the U.S. citizen or legal permanent resident must file the necessary petition on behalf of their relative. There are several requirements that must be met in order to be eligible. In addition, an immigrant visa must be available at the time of filing. As we will discuss, visa availability proves to be one of the most burdensome requirements. Family unity is a cornerstone of Catholic social teaching, and their well-being directly impacts the welfare of society. However, the current process for family-based migration is such that more often than not, families are forced to endure extensive periods of separation while they wait for an immigrant visa to become available, leading to missed milestones, distance, and suffering. This is because the family-based migration process is subject to a number of quotas that directly impact visa availability. While visas for immediate family members of citizens are unlimited, the law caps the visas available in the preference category at 226,000 per year. This also includes a cap for each of the 5 preference categories and a cap of 44,100 family-based immigrants from any given country. Every year, the number of petitions far exceeds these quotas, which has resulted in a considerable backlog. In 2022, family preference category petitions made up about 86% of the family-based backlog, and about 8.3 million immigrants total at various stages of the family-sponsored process. In practice, what this means for some families is that certain family members could have to wait decades before a visa becomes available to them. Current wait times can range anywhere from 6 to 233 years, making reunification impossible for some families, especially those who are from countries with a higher level of applicants. The backlog is further exacerbated by the fact that hundreds of thousands of green cards go unused each year due to a range of administrative complications. How can this be improved? Congress has the ability to improve this process by modifying the existing quotas that impact visa availability and create the excessive backlogs. Congress can also act to authorize what is known as visa recapture, which would collect and make available the total number of unused visas since the 1990s to the applicants who are currently waiting in the backlog. These steps could help to alleviate the backlog by making more visas available to families.